morning and welcome to our presentation by Robert Wood of Wood LLP in San Francisco, California. Rob Wood is often listed among the top 10 tax lawyers in the country. He's a widely published author known for explaining and demystifying complex tax concepts. Rob is best known for his expertise advising plaintiffs, defendants, lawyers, and settlement funds on settlements and judgments. He authored the leading book on this topic, Taxation of Damage Awards and Settlement Payments, which is in its 5th edition, 2021, as well as the Bloomberg Tax Management Portfolio, Tax Aspects of Settlements and Judgments. He's the author of numerous other tax books and hundreds of articles. He is listed among the elite tax lawyers in the United States by many Best Lawyers periodicals. Rob writes regular columns in Tax Notes, Forbes, and other publications, and comments on tax matters in the media. And what particularly attracted us to Rob for today's presentation is an article that he wrote in the Daily Journal a few weeks ago, IRS Tax on Legal Settlement Agreement, Watch Your Wording. Now, this article in the Daily Journal, which is our leading legal newspaper here in California, talks about the tax implications of settlements. And as mediators and lawyers involved in settling cases, we have to be cognizant of the tax consequences of what we're doing. And Rob, we welcome your comments. We look forward to your insights, and I think they'll be very practical for us in terms of guiding us how to go forward, how to avoid traps for the unwary, and perhaps how to avoid malpractice liability for ourselves as well. So Rob, to tell us about a food bank that's important to you and then to hear your words of wisdom, my friend, the floor is yours.
Thank you, Jeff. Nice to be here. Yes, I designated San Francisco Marin Food Bank, which is near me. And I'm going to talk about the tax treatment of settlements and judgments. Everyone, I'm sure, lawyers, most, if not all lawyers and mediators at some point are forced to deal with this topic, like it or not. It is any time money is changing hands, you typically have tax issues. And I'm particularly interested in trying to get ahead of the issues. I see sort of cases, as many of you do, I'm sure, at sort of all different times. And so sometimes that's after everything is done, signed, sealed, and delivered, and oftentimes in the next tax year. So if you get a settlement in one year, this year, for example, and you may wake up to the tax issues in January when IRS Forms 1099 arrive in the mail, or you may not thinking about it until you sit down and start thinking about your tax return in April or October. So the earlier the better on these issues, like most things, I guess, is best. And Jeff, please interrupt me anytime and fire away with questions, because I'm sure you'll have some.
Thank you, I will.
Everyone, I think, probably knows the basic rule, because it's often repeated. I also don't find it a terribly helpful rule, but it's something the Supreme Court says a lot, and that is that the tax treatment of a settlement or judgment depends on the origin of the claim. So you're supposed to look at what should have happened originally. How would the money have been paid if there wasn't any breach of contract or wrongful termination or auto accident or whatever it was? So it's looking to the genesis of the dispute and what the money is really supposed to replace. Those are kind of the concepts that the IRS and the Franchise Tax Board in California and the courts use in determining how to tax something. So that would tell you, for those of you who are litigators or mediators, you'd look at the complaint. The mediation briefs, I always find, are super helpful to me, because of course they're prepared for mediators to kind of distill the case, which I like. It's kind of a succinct description of what the case is about, what the defendant allegedly did, the damages, and so on. So, so those things always inform the tax treatment. And I think though, in the article that Jeff is mentioning, focuses, as many of mine do, on settlement agreement language. It's surprisingly, I guess I would even tell you as a tax lawyer, shockingly important how the wording really matters in a settlement agreement. So given what I've told you, you might reasonably think, well, look, all of these things in the course of the case are relevant, and the complaints are only relevant, discovery is relevant, all these things, all of which is correct. It is relevant, but very frequently, and I should say that sometimes cases get settled with a general release, or what I call, I don't know if that's the right term, but I would call general, meaning it doesn't really say very much at all. It's just you release everything. It might even be mutual. Everybody releases everything, and here's some money. And so somebody has to figure out the tax treatment of that. But the IRS and the Franchise Tax Board and the courts, the tax court is where many federal tax disputes end up. And that's primarily because you don't have to pay first to go to district court or claims court. You have to pay first and then argue about a refund. So most things seem to, at the federal level, if they're going to court, they end up at the tax court. And the tax court has been saying in a series of cases, we really are looking at what the complaint says. It's going to say what the money is for. It's paid on account of X. And if it says personal physical injuries, that's likely to be excludable. If it says emotional distress, even if it looks like the person was in fact physically injured, we're not likely to say that it's tax-free. So I would only say, and I think Jeff said this in his introduction, settlement agreement wording and is really important, and it's important for malpractice liability as well as before you reach that point, sort of what the plaintiff's going to get. So I'd like to kind of run through some basic concepts, a couple of which I guess I just assumed. One is this origin of the claim doctrine. Something else that's fundamental is settlements and judgments are essentially taxed the same. It's the same set of rules. However, I would certainly say, I think most tax people would, settlements are almost always better. In fact, I probably can even drop the almost. They're always better because you got more flexibility. A judgment, you get what you get. I've seen people, and I've tried to do it myself, sort of try to steer the wording of a judgment for particular tax concepts, but you really, as a practical matter, there's so much going on, and in a trial, as most of you know better than I do, and it just doesn't work out. So you're sort of stuck with a settlement. You've got a lot of ability, assuming you've got willing parties. You've got a lot of ability to steer it. And by the way, mediations are an ideal place. I think there's one article on my website called something like "When Mediating Disputes, Think Taxes," and I've written variations of this concept. By the way, if I allude to my website, you can, many, if not most of my articles, you can go to my website and there's a search engine somewhere there on the articles page and type in a few words you can remember from an article, and you should be able to get it. Because I personally do this all the time. I remember I wrote some article on the tax treatment of Roundup verdicts, and I think Roundup, or I type in weed killer because I remember I used that word, and I usually get it. So, but mediation is an ideal place to plan ahead, and then if you're about to sign a term sheet that the mediator is hoping is signed before everybody leaves, think about whether you want to insert any tax wording in it. certainly if you're hammering out a full-blown settlement agreement, as is sometimes done in mediations, definitely there you need to address taxes. I think that's true for both defendant and plaintiff. Plaintiff is more worried about taxes, but if it's an employment case and you're representing an employer, you don't want to, you want to think about, is this W-2 wages? Is it on a 1099? Is it, some of each? How are you paying the lawyer? Are you splitting up the checks? Those kinds of things. And of course, the real wild card is the plaintiff says some of this money is for physical sickness or physical injury. The plaintiff may say, I have post-traumatic stress disorder, which is very common these days in employment claims and other contexts. But what are you going to do about that? And you have plenty of time to iron these things out if it's a settlement agreement that's being negotiated over a couple of weeks. But you don't have a lot of time if you're doing it late the night of the mediation.
Well, Rob, the lawyers who are involved in employment cases typically are not doing their first employment case. They're typically specialists, people who focus on that either on the plaintiff side and on the defense side as well. And yet still at mediations, we do at the end of the day, when these documents are being prepared, have squabbles about such things as the 1099 versus the W-2 and how to characterize things. Does emotional distress count? What kind of physical injury counts? Can we run through some of these things and talk about what some best practices might be if people are trying to keep the money away from Uncle Sam?
Yeah, sure. And I'd be happy to.
Go for it.
Well, so I guess first, this would be a good segue to another fundamental rule, which may not surprise most lawyers, but it certainly surprises clients, I'd say almost every time. And that is the Banks case. Banks was a U.S. Supreme Court case in 2005 dealing with the tax treatment of legal fees, attorney's fees. So and there had been for decades a split in the circuits, all sorts of disputes about how legal fees, and I'm talking primarily about contingent fees, how they would be taxed. So it's $1 million, forgetting about what kind of case it is, $1 million case, lawyers getting $400,000, 40%, clients getting $600,000. Who's getting what? And I think you probably all know this. The basic answer is in that however the checks are cut, the U.S. Supreme Court and the IRS are going to say that the client got $1 million. Even if the client doesn't see the 400, it's netted out by the lawyer before paying the 600 to the client. So that's the result. And that's pretty uniform. There's some sort of there are some exceptions. There are some gray areas for sure, but the basic rule is you got to worry about the $1 million. And Jeff, this ties into your 1099 point. So there are still a surprising number of fights about is the client going to be attributed the $1 million or not. But the basic rule is that even if it's all on a 1099, the client in that example is going to get a 1099 for $1 million, not for 600. So, and the reason, I guess it's important because that's the rule and people fight about it. But it's also important because many clients since 2018 have trouble deducting legal fees. Now, and that doesn't apply to employment cases, which Jeff, you just mentioned. So in an employment case and in many others we can talk about, there's a deduction for the legal fees. And it's a so-called above the line deduction, meaning that it's sort of gold-plated. It's kind of like not having the income in the first place. So, but why don't we? Do you, Jeff, want to throw out some examples of employment cases settling, or you want me to make some up? I certainly can.
Well, let's just take an employment case which settles for $1 million. And there's 40% of that goes to the lawyer. In many mediations, the plaintiff's lawyers do request two separate checks, one to them,
Yep.
their fee plus perhaps reimbursement of the costs, and then another to the plaintiff for the 600 or 600 less costs, thinking that that will effectively minimize the client's exposure to taxation on the money that ends up in the attorney's pocket. Does that work?
Well, there's a couple of couple of questions I think embedded in that. And first of all, in an employment case, it would be unusual for there not to be some wage claims. So I mean, I see lots of employment cases as they're settling, but in my view, it is good for the employer and good for the employee or former employee to have something in the wage category. And by that, I mean, out of the $1 million, you pick a number that seems reasonable on the facts. Maybe it's $100,000, maybe it's more, but it's an amount that is treated as wages and reported on a W-2. And that to the employee, and that means there's withholding taken out, they get a W-2, that money is separately paid just like the regular payroll check. Is that 100,000 a reasonable number? I mean, it really depends. It should be informed by the facts. So an awful lot of employment lawyers on the defense side that I've encountered, and this is the policy of some big companies, say, oh, we always do 50%. And there's some sort of misbelief that there's a safe harbor always for 50%. There isn't, but I think the theory is you can't be criticized for sort of splitting the baby. It all depends on the facts. So there are cases where, for example, an employee is on paid leave or something like in some kind of a dispute, but on paid leave, so they're getting all their pay. And maybe most of their claims are not about future wages or something. I mean, there are cases where it's settled and there's no wages, and the settlement agreement might say, we all agree that there are no wages being paid here. This is all money that's emotional distress damages or something. So as to the, I mean, first, you didn't ask about wages, but first think about wages. And by the way,
your message is don't be greedy on it, because there are some lawyers who will say, well, we want the whole thing put on a 1099 rather than a W-2. Some people mistakenly think that avoids taxes rather than defers them, as I think is the case in some circumstances. But your advice, I think, is unless it's really a clear-cut case, put some material portion of an employment settlement onto a W-2. Otherwise, you're being too clever by half.
Yeah, I would. And I also think, and I know, I mean, I think it's a difficult dynamic, getting a case settled is, again, you as mediators know better than I do. I mean, there's sort of a push me, pull you, sort of this, it's difficult to bring it all together, and the tax issues, are not easy either. And so, everybody's tense. So, but yeah, I think something in the wage category is best. The plaintiff's employment lawyer may logically be saying, I got to get a bigger take-home check to the client. If taxes are taken out of this, they're going to be even more upset. And conversely, maybe the plaintiff is saying, absolutely not. I don't want any taxes taken out. The one thing which probably most of you don't have to worry about, but I see, is what happens if this is a person who's never, the plaintiff, who's always been a wage earner, never before gotten a big slug of money that it doesn't have withholding. So they have to worry about estimated tax payments. They get it in October or something, or they get it in February of a year, but then taxes on that money are really not due until April 15 the following year. Sometimes people have spent the money or something. So it's worth thinking about these things in advance when you don't have the midnight oil burning. It's fine to cut up the checks and have them go separately, but it's almost always the case that in this $1 million example with 400,000 of fees, that the client's going to get a 1099 for $1 million, or if there's a W-2 for part of it, whatever is left, including the lawyer's fees, are going to end up on a 1099. So it's and this is, if you're not a tax person, sort of this is not your job, but somebody needs to explain to the client that they can deduct the legal fees and sort of how to do it. Every year, I get a surprising number of calls from or emails from clients or prospective clients or accountants who can't seem to manage to do the legal fee deduction right. And a lot of them, do it wrong, but the law is clear that they get it in an employment case.
So the 1099, to whom does that go when the settlement proceeds are made to the trust fund of the plaintiff's lawyer?
Yeah, that's another good issue to talk about. So if the settlement, the normal answer to that, certainly the answer if you're a defense lawyer, would be the 1099 goes just like we discussed, meaning the lawyer gets a 1099 for the $1 million and the client gets a 1099 for $1 million. There are hundreds of pages of regulations, Treasury regulations on 1099s. There are lots of rules, but one of them that's sort of important in this context is duplicate 1099s. And this has been, I think, maybe since 95 or something. It's been in the law for a couple of decades. And duplicate meaning we don't, as the payor, the defendant paying that $1 million. Yes, Jeff, as you just said, they're paying the trust account of the plaintiff law firm, but they know that some of the money is going to the lawyer and some of the money is going to the client, and they don't know in what percentages. And they don't know what the split is, and therefore they're required to issue a 1099 to each.
Even though there's only $1 million being paid, there are two $1 million 1099s being issued.
Yeah, and I mean, I sometimes get people, I sometimes, it's sort of a shoot the messenger syndrome, I guess. I sometimes get really irate phone calls from lawyers about this very issue, or irate emails saying, this is unconstitutional. How, why hasn't this been challenged? We can go to the Supreme Court. It's double taxation and so on. I mean, it really isn't. Well, at least I'd be happy to do, try to change it on an hourly basis. I certainly wouldn't do it on a contingent fee basis. It's not duplicate taxation for a couple of reasons. On the lawyer side, the good news is, and hopefully all of the lawyers know this, almost every 1099 that the lawyer gets, it for people in private practice or mediators, I guess anybody who, we all want to be paid. It's useful to look at the 1099s you get. The very sort of small offices, sole practitioners, maybe you see them, but other people may not. But it's really interesting. So if you settle this case, this $1 million case, and you, as I've just told you, the lawyer or law firm gets the $1 million 1099, and you think, geez, that's not fair. We got a $400,000 fee, and we got to pay tax on $1 million, or explain it on our return, or so on. And the answer is you don't. You have to pay tax on the $400,000, and that's what you report, because the 1099 that lawyers get says gross proceeds paid to an attorney. So if you look at a 1099 miscellaneous form, 1099-MISC, it's box 10 on the form, gross proceeds paid to an attorney. It's a special box on the form for lawyers. And here's the real kicker. It doesn't get tracked as income the way other 1099s do. So if you got as a lawyer, you got a, and again, it's worth looking at these forms. If you get a 1099 miscellaneous box 3, other income, that's other income. That gets tracked, meaning if you don't put it on your return, and I guess in my example, you'd put the $1 million and you'd show essentially a deduction or offset for the 600 paid to the client, distributed to the client. And then you pay on the 400. But with a gross proceeds 1099, you don't have to do that. So it's not double taxation to the lawyer for that reason. And for the client, again, the Supreme Court said it's really the client's income first, and then the client pays you, the lawyer, and therefore the client has to figure out how to deduct the 400. If it's an employment case, there's this kind of mechanical issue with claiming it correctly. Since 2004, when this went into the tax law, the IRS has not done a good job on the form. Still the same way it was in 2004, which is not very clear. But in lots of other kinds of cases, since 2018, there are, you have to do all sorts of creative things to be able to deduct the legal fees.
And this is true in personal injury cases as well, Rob?
Yeah, so let's talk about that for a minute, because that's so in a personal, I always say, although the idiom, I guess, is, as you just said, a personal injury case, I try to always say personal physical injury, because there is a important kind of a pivotal tax distinction between personal and physical. And so and on that point, the tax law section 104 of the Internal Revenue Code said, and I don't know how many articles I've written about this distinction, says that a recovery damages for personal physical injuries or physical sickness are tax-free. It's section 104. It's pretty short tax code section. And it's been in the law for 80, 90 years, as long as the tax law has been in effect. So if it's a real injury case where someone is injured, then I'd say you don't have to worry about the legal fees. In other words, it doesn't really matter in the example whether we're talking about $1 million to the client who pays the lawyer or a net of 600,000. If it's all tax-free, it doesn't matter. In contrast, what if it's an emotional distress case, intentional infliction of emotional distress? That's certainly a personal injury, but it's not a personal physical injury. And since 1996, this is when the tax code was changed, Congress inserted the word physical a couple of places. Physical injuries or physical sickness. So if you, as a mediator, when you're resolving a case, have a plaintiff, a lawyer who's telling you, no, we don't want it on a W-2, we want it on a 1099, it's for emotional distress, that way it's tax-free. The last part of that sentence is just wrong. Emotional distress, that's what, so it's tax-free. That was true before 1996. It's no longer true.
So here's something I've never understood about that, Rob. When I read about psychiatry and neurology and psychology, and they talk about things like anxiety and PTSD, they talk about the functioning of the brain, and that all of these emotional distress syndromes and all of these mental illnesses and injuries, they take place someplace in the functioning of the brain. The brain waves are altered, the brain chemistry is altered, all of that.
Yeah.
If that's true, then why are these not physical injuries? Because they are reflected someplace in the actual physical functioning of the brain and the nervous system.
Yeah, I mean, I wish I had a better answer for this. I mean, I agree with you, or the way you're asking the question, which suggests an answer, which is, hey, this is as physical as getting wrapped over the head, and maybe longer lasting injuries too. So I agree with you. I mean, the law, the tax law is highly disputed on this point, and that's been true really since 1996. But there are no good answers. I would say that it's clear that emotional distress, plain old emotional distress, is taxable. It's clear as a bell. But what is emotional distress versus something that's more serious? I'd focus on. I mean, there are tax cases, people who've gone to tax court with employment settlements in particular, who essentially have emotional distress, then they have a variety of physical symptoms, some of which are fairly serious. And in general, people lose those cases. People have lost on the question of, is depression itself a physical injury, even maybe a major depression. Post-traumatic stress disorder, I put in a different category, a better category from a tax viewpoint. And that is because number one, I think the case for treating that as itself a physical injury or physical sickness is pretty strong. And I've written a bunch of tax opinions on it for clients. I see it a lot. I see the claims a lot. And I've seen a lot of defendants, when they're trying to settle a case, I mean, the dynamic is kind of once the settlement agreement is signed, it's a done deal. And I've seen many people over the years try to go back later, either defendants or plaintiffs. Usually it's plaintiffs trying to say, wait a minute, you got to change this. You issued the 1099, you should undo it. Or we need to change the wording, we need to amend it. And most of those requests, needless to say, don't go anywhere. But the wording in the settlement, I've seen a lot of defendants who are willing to treat PTSD as that occurs, for example, in the workplace, or was caused or exacerbated by the workplace, as physical injury, physical sickness, therefore no 1099. So there is no tax case yet that says conclusively PTSD is, a PTSD recovery is tax-free, but there's also no tax case that says the opposite. And to go back to where we started, Jeff, you commented on an article I wrote and commented on how important wording is and so on. It's really true in spades here. I mean, the wording, hammering out the wording in a settlement agreement is surprisingly important. In one, kind of real life example, I'll tell you of why it's so important, is if you're a taxpayer, you never want to be in the tax court fighting about something. What you want to do is never to be audited, of course, but if you're audited, what you hope for is kind of the silver bullet or the magic, document that you can give to the IRS or the Franchise Tax Board, which, by the way, is active in auditing, sometimes even more active than the IRS. You want to be able to give them something that makes them say, oh, okay, I see now, thank you, and that's it. And the best thing you can do if you're audited and you're a plaintiff is have a really good settlement agreement that makes it clear. They always have the ability, as a legal matter, to say, oh, but we want to see more. But what does the complaint say? This says PTSD. Where, do you have a doctor diagnosis? Or, where are the pictures of the bruising that when the guy grabbed you in the lunchroom at work? So, they can always ask those things, but I've had a lot of audits that have resolved easily because of really good wording. So it's worth fighting for.
With the understanding that you're not giving legal advice on any particular matter, are there some is there some magic language, some ways of phrasing things which, generally speaking, are better than others?
Yes, and on this point, I think it would be something on the order of the parties agree that a particular payment is paid on account of, this is the language that's used in the tax code, on account of as opposed to for. I'm not sure that that matters too much, but on account of personal physical injuries and physical sickness. So those, if there are magic words, I guess those are the ones. And I mean, you certainly can't say that if it's an antitrust case that's resolving, and I'm sure nobody would. But as all of you know, in a case, employment cases being a good example, but there are other contexts too, where you have lots of kind of he said, she said, and kind of nobody agrees about anything. But fundamentally, if the parties are comfortable doing it, those would be, I guess the best words in terms of achieving an excludable recovery. I go on, and I don't always get this, but labels matter in the tax world, and so I would go on and say something like, as the parties agree that this payment is excludable from income under Section 104 of the Internal Revenue Code, there will be no Form 1099 issued to plaintiff. Now, why does that help? Well, number one, I'm leapfrogging, a couple of years later, thinking if this is audited and the settlement agreement is sitting in front of the IRS, they're going to really like that. It really is a super detailed roadmap. You don't have to have it. And sometimes defendants say, well, wait a minute, we're not agreeing it's excludable. We'll agree to call it that. And, maybe we'll even agree not to issue a 1099. But it's worth asking for. If you don't ask, you won't get it. The 1099 point, I guess I'd say, is a common bone of contention. So many plaintiffs and defendants can work out wording, and let's say that the defendant agrees to some of what I've just said, but not to all, and they say, fine, we'll agree. And by the way, they may say, we're not going to say this is for personal physical injuries, well, because we don't even know that there are any. We'll say it's for alleged, because we still think that there weren't, and so on. You've been through those sort of wordsmithing exercises. But they may be comfortable saying that it's for alleged personal physical injuries, but they may say, but we're not convinced, you sent us the medical report, et cetera, but we're not convinced, and we still want to issue a 1099. That could be sort of a separate discussion, a separate hour or more discussion.
Yes, Rob, it's unusual in my experience in employment cases for there to be a discussion of not issuing a 1099 at all. Usually the discussion is about W-2 versus 1099, but you're saying that in the case of personal physical injuries, that perhaps it's appropriate for the employer not to issue a 1099 at all?
Yeah, I am. And I may, I see a lot of employment cases. I think you're right. In most employment cases, there's no sort of credible case for an exclusion, and so the arguments are typically over the W-2 versus the 1099, and then how the 1099 forms will go. But yes, I am saying that if you have an employment case that's settling, or some other kind of case, and the plaintiff is claiming, for example, post-traumatic stress disorder, it's appropriate for the plaintiff to say, I want this piece of the money treated as for my PTSD/physical sickness, and therefore no 1099. The instructions to Form 1099 miscellaneous say, if it's a payment for physical injuries or physical sickness, you should not issue a 1099. And that's in the regulations too. But as I say, I mean, this is a common bone of contention, and many defendants will agree to wording, but will say we're not quite over the hump, and our compliance department, legal department, whoever is telling us we still are going to do it. So sometimes that's the compromise that's reached as well.
So let's say the claim is the emotional distress caused an ulcer. Does that count as a personal physical injury?
The way you just said it, and this is, I know, sounds silly, but the way you just said it, the answer is clearly no, that does not count as something that's tax-free, because you said it, well, let's say the emotional distress caused an ulcer. So there, the emotional distress came first, and there are physical symptoms from that. The IRS would say, I mean, I could argue to the contrary, but the IRS would say that the emotional distress came first, and it's clear, and there's a committee report from 1996 on this, that talks about how when you're deciding physical injury, physical sickness versus emotional distress, which is taxable, you got to look at the order of events. And emotional distress, which causes physical symptoms, that's not physical sickness by itself. In contrast, if you had asked the question, let's say, the bad employer allegedly caused me to have an ulcer, that would be different. And I'd say, hey, an ulcer is physical sickness. There are two famous cases, and I've written a lot about them, famous tax cases, both in 2010, coincidentally. One, and if you type in these names on my website, you could get articles on them. One is called Domeny, D-O-M-E-N-Y, and the other one is called Parkinson. These are both the names of the taxpayers who were plaintiffs. And Domeny was a woman who had MS, multiple sclerosis. She goes to work telling the to a new employer, telling the new employer she's got MS. I don't remember if she needed some accommodation or something, but she had MS. And the employer was doing some allegedly bad things, some kind of accounting fraud or something. And so she became highly stressed. Her MS got much worse, her symptoms spiked, and so on. Anyway, it ends up in a lawsuit settlement, and she excludes a piece, half as I recall, of her settlement. It goes to tax court. The IRS keeps saying, hey, look, this is just emotional distress type recovery, taxable. The tax court sides with Domeny in saying, no, this exacerbated her physical sickness, tax-free. Parkinson, I don't know, maybe even more dramatically, Parkinson was like a hospital manager or something, some kind of a hospital employee, and said all the extra demands that we're putting on him caused him to have a heart attack. It's an employment case, but his heart attack money in the case gets excluded on the same theory, physical sickness. So, an ulcer is not to that level, but still, that's real. And I would say, there's another article I think that on my website called, if you type in chicken or egg, I know you'll get it, because it's a chicken or egg issue, and how you phrase things matters.
And that's as true at the pleading stage as it is at the point where we're documenting a settlement.
Yeah, and I occasionally get true, and you're not, if you're a mediator, you're not going to be involved at the pleading stage, and I'm typically not either. Once in a while, I get hired as somebody's planning a case, but I would only tell you that, and most lawyers, can't be expected to, worry about things like that when they're doing the pleading. They're just trying to, maximize the recovery and make sure they get all the claims in. So I think oftentimes it may, back to your ulcer example, it really is, I suppose, and has been pled as, hey, really the emotional distress and really upset all the time, and look at what happened to me. I mean, that's how all of us think, I think. Look what you did to me, all these bad things. But I think one more reason to focus on the settlement agreement, and if you can get the right words in the settlement agreement, then these sort of chicken or egg things that are awfully hard to untangle may not matter so much.
Let's talk about another kind of claim for perhaps physical injury. We've been talking about ulcers and MS and other things which are manifestly physical. In some of the Me Too and the sexual harassment cases, there are allegations of battery,
Yep.
physical contact, unwelcome touching. It doesn't cause bruising, perhaps, and there's no broken bones involved, but it's still clearly touching of a sexual nature, highly inappropriate. Does that count because there is a technical battery? Does that count as a personal physical injury?
It does, or it can, and you're doing my job here, which I appreciate. I should have said a long time ago that at the outset of this talk that that sort of observable bodily harm, that phrase, which I kind of hate, but what does that mean and why does that get thrown around? So the IRS in the early days after this 1996 change started talking about, well, the best way, we need to see it. We need to see scratches, scrapes, broken bones, bruises at least. That's how we're going to decide what's physical. And by the way, that's dropped a little. It's not discussed much anymore because there are, again, cases like Domaini and Parkinson. I mean, certainly those, physical illnesses were observable, but you don't have to be touched. But you're absolutely right. In the sexual harassment context or abuse context, that helps the plaintiff get it. It's good, it's good that those, from a tax viewpoint, it helps the claim that something ought to be tax-free. Maybe all of it. I think the difficulty is sort of what happened afterwards. How did the plaintiff react? And very frequently, unless it's a violent attack or something, that or there may be no outward signs. I mean, even if it's a rape, a sexual battery of some sort, there may not be bruises that you can see. The IRS, in kind of a famous informal, non-official sort of ruling, I think it was in 2008 maybe, issued something that was about sex abuse of minors and a person who's an adult getting a recovery. And the IRS, I've written about this one a bunch too, but the IRS sort of painstakingly says, we're looking for observable bodily harm. And you can tell they correctly wanted to say this money should be tax-free, but the adult person who was abused as a child can't show anything. And so the IRS basically says this person was a minor, and given the nature of the allegations, we're going to presume, in some cases you can presume that there once was observable bodily harm. But in a sexual harassment, if there's unwanted touching and then there's emotional distress, or especially, as frequently I see that there are claims that the person has PTSD, I say for the plaintiff, that's a good case for arguing hard for treating it as tax-free. Some, or maybe even all. When I say that, I'd say most employers are going to say, look, we're still treating a bunch of it as wages. It's an employment case, for crying out loud, and let's treat X percent as wages on a W-2 with withholding, and then the rest of it, arguably should be treated as physical injury, physical sickness money, hopefully with no 1099.
Fascinating stuff. One last area to get into, Rob, before we end our recording here. It's November, and when we get into the fourth quarter, and particularly into our mediations in November and December, plaintiffs will sometimes ask for the payment to be made in early January of the following year, or portion of the payment to be made in the next year. And the theory is that gives them 15 months to hang on to the money before the taxes are due to the government. Does that work?
Yeah, you're absolutely right. Late in the year, even even around September, I start to see this. So requests for pay me next year. Absolutely, if it's done properly, it works. And by done properly, I simply mean that the settlement agreement, before it's signed, needs to say when the payment's supposed to come. So if you wanted a payment in 2 installments, pay me some now and pay me some, between January 2 and January 15 or something. That, for tax purposes, that's binding. That works. In contrast, if you signed it and signed it in November 1st, and it says we're going to pay you in 30 days, and then after you sign it, by you I mean the plaintiff goes back and says, well, wait a minute, I decided I want it in January. Can you pay me in January? The employer or defendant, whatever the case is, the defendant might agree, and it might be fine. They might do it. But technically speaking, in that example, the plaintiff has income this year because it was signed releasing their rights. They had a right to the income now, and they tried to push it away. It's kind of the pay me my Christmas bonus next year example that the IRS might use. So that's how it works. I'd say it's especially hard. This with the tax proposals floating around. Most of them are, I think, settled now, at least for the short term. So I think people are doing that. But I think earlier in the year, everyone was trying to hurry up or at least that I saw was trying to hurry up and do things, hopefully before tax changes happened.
Rob, I have one more last question before we end up, and that is sometimes when some of the more, shall we say, aggressive tax strategies are implemented through a settlement agreement, an employer or other defendant will ask for some sort of indemnification provision in case the IRS sees things differently. Comment on those, please.
Yeah, I mean, I'd say it's a great topic. Is even a good separate topic. It's just sort of like 1099s is a great separate topic. Tax indemnity provisions are almost universal in settlement agreements, at least that I see. There are lots of different flavors, and I think if I'm representing a plaintiff, obviously I will tell almost all plaintiffs, if you have to agree to some kind of indemnity to get what you want, you should do it. Once in a great while, not often, but once in a great while, I see plaintiff lawyers who are also willing to indemnify. But as I say, that's rare. But the question, of course, is what's the scope of the indemnity? It can and should say, probably always says, plaintiff agrees they're going to pay any and all taxes that they owe, the taxes that are assessed against them. And that, I think, should be easy to get any plaintiff to agree to. I think the tougher one in employment cases is, let's say that the plaintiff has argued hard saying, I only want 20% treated as wages and 80% on a 1099. Let's just forget an exclusion for a minute. And the defendant says, we'll do what we want, what you want, but you got to indemnify us because we think more of this is really wages than 20%. So the plaintiff might be asked in that circumstance to indemnify the employer in the event that the IRS says more of its wages. In that example, I would be asking for that probably as the employer on that side, but I would tell the plaintiff not to agree to that, or at least that there's a risk, because failure to withhold penalties are big. And if the plaintiff is taking that responsibility on, I would probably argue to the plaintiff, look, you're better off just agreeing to more wages. Let's agree on what a reasonable number is. But I mean, I'll see some plaintiffs who will agree to that kind of broader indemnity.
And of course, from the defense perspective, collecting that money back and enforcing the indemnification against the employee, unless we're talking about real big dollars, that can be quite a challenge too, can't it?
Yeah, I mean, that's the other thing. I've been doing this an awful long time, and and you know, when the smoke clears, everyone, you know, the case is resolved. And I mean, what people want is never to deal with each other again. And so I think a couple of times, maybe twice in my career, I've been on phone calls with defendants and the, you know, counsel and this kind of thing, saying that they had some kind of a tax problem, and that you know, they should go after this person. I've never seen it done. That is, I've heard somebody on the call say, rightly, you know, this is nuts. You know, we're going to get sued all over again. There's no, you know, we should just deal with the thing. It's not that big a deal. We shouldn't try to go and, you know, get whatever it is out of the plaintiff.
And trying to withhold money as some sort of holdback, that almost never goes down in a settlement.
Yeah, I mean, I'd say that's true too. But the other thing, I mean, this whole, you know, another thing I've learned from doing this for a long time is that I can try to explain what I think the technical issues are, and how they mesh with the facts, and what the tax treatment ought to be, I think, and what the range of permissible tax treatments ought to be. But ultimately, taxes aren't going to drive the settlement. I mean, they're often used as either a sort of a carrot or a stick, and they can help bring the parties together. That happens a lot. Mm-hmm. But ultimately, I may be saying to somebody, let's say it's on the defense side, look, I really think you ought to be withholding, or look, I really think you have to issue a 1099. But somebody who has the general counsel, let's say, may say, no, we know that, but the tax risks here are smaller than the other risks. We need to settle this case today. If we have to do what they want to settle it, that's what we're going to do, because we don't want this, we don't want the complaint being filed, or we don't want this case on the evening news. So, I mean, the tax things sometimes fall by the wayside in view of bigger things.
Rob, our time is about up. This has been fantastic. I just want to say, in the very best sense of the word, this has been an exhilarating conversation. It's just, in the best sense of the word, it's a couple of nerds talking to each other about taxes and economics and law and all negotiation and all this kind of thing. And it's been a most worthy and valuable hour. I think the San Francisco Marin Food Bank is going to receive a lot of contributions in your honor as a result of our conversation today. Thank you so much, my friend. And with that, we are complete.
Very, very kind of you. Thanks, everyone. Bye-bye. Thanks, Jeff.
Thank you.